York Times, and Alan Tarr of Rutgers University. And I think everyone on the panel is going to speak to both federal and state courts. So we'll get a little look at all the governments. It's going to go in the order of Jim, Alan, and Adam.
Well, I'd like to begin by thanking Sandy and the University of Texas for what I think we all agree has been a great conference. So thank you all very much. My talk is a little bit different to what we've heard in the last couple of days. It's different in the sense that I want to advance a theory of institutional health that's a little bit different. And I also want to produce some data on the health of American institutions, with particular focus on the U.S. Supreme Court and on the state courts as well. The theory that I want to put before you today has to do with institutional legitimacy. And the first step in understanding this theory is to note that we have to distinguish between performance satisfaction, that is, attitudes or judgments toward the incumbents in an institution at any given point in time, and attitudes toward the institution itself. We define legitimacy as loyalty to an institution even when it makes displeasing decisions. I always say that legitimacy is for losers. What I mean by that is that those who win in political and legal disputes very rarely challenge the authority of the decision maker. But those who lose often will ask, is my losing fair? Does the institution have the right to grant me or give me this loss? So legitimacy is primarily important for those who lose in political and legal disputes. It's especially important for institutions because it makes them untethered from majority opinion. That is, it frees them to be able to make decisions that go against the will of the majority at any given point in time. You can easily see how important this is for courts because they're so often charged with acting in a counter-majoritarian fashion. Legitimacy allows them to do so. David Easton, who created a lot of this theory, coined a great phrase, at least a phrase I like a lot, and that is that legitimacy constitutes a reservoir of goodwill that allows institutions the freedom to decide as they think appropriately. Now, I can talk a lot more about the theory, but I'll just give you the case of FDR and the court packing in the 30s. I realize that that controversy ended in an ambiguous way, but one way to understand what happened is that FDR's attack on the court, the integrity of the institution itself, the fundamental structure of the institution, that attack failed because the appeals did not resonate with the American people because they granted the Supreme Court so much institutional legitimacy. So I'm going to contend that an essential element of governability is the ability of institutions to maintain their legitimacy and go about their jobs. Now, we talked yesterday a lot about Congress, and we talked about performance satisfaction, and that's a question, generally speaking, that says how well is Congress doing its job. That's what I refer to as performance satisfaction, and that question is asked all the time. Now, you've got to be a little bit careful, however, because the question that asks about confidence in the leaders of, a question that survey firms use all the time, turns out not to be a very good measure of legitimacy, but instead is very highly contaminated by this performance satisfaction. So one has to be very careful in interpreting public opinion data and know if you're talking about either institutional loyalty and support or satisfaction with the incumbents at the moment. Now, we've been measuring the legitimacy of the U.S. Supreme Court for 20 or 30 years, beginning in 1987, and I can give you a little bit of the flavor. You can't read this, and this, I tried to get those monitors working, but I couldn't. But there's 7 items that we often use, and I'll just give you an example of one. If the U.S. Supreme Court started making a lot of decisions with which most people disagreed, it might be better to do away with the court altogether. We also ask questions about whether the court is too political, whether its independence could be reined in, and that sort of thing. So these are the measures that I have consistently used to measure legitimacy, and I'll tell you just a little bit about what we've found over the last couple of decades about the legitimacy of the Supreme Court. First, the court's legitimacy among the American people, and by the way, this is what the legal scholars call sociological legitimacy. It's empirical legitimacy. It makes no normative claims about being right. It is simply an empirical assessment of the views of the American people. So the first thing that we've discovered is that the court's legitimacy is actually quite high among the American people. It's always hard for survey researchers to provide point estimates of public opinion, but most people in this country extend a considerable amount of support to the Supreme Court. One basis of thinking about that is to compare the results cross-nationally. Again, I realize you can't see this, but what you can see is gigantic variability across countries where we've done this research in the legitimacy of courts. The rightmost figures over there are all taken from the U.S. Supreme Court. The only institution that really comes close, in fact maybe even exceeds the legitimacy of the U.S. Supreme Court is the German High Court. I don't speak German, but it's Bundesverfassungsgericht. You might know it's the longest name in the world of any institution. But the Federal Constitutional Court in Germany is about as legitimate as the U.S. Supreme Court. A second thing that we found is that there hadn't been much change over time. This is just one question, and again, all I really want you to see is that the level of support for the court is high and has been high from, in these data, 1987 all the way up to 2008. The court's institutional legitimacy in the last several decades has simply not changed very much. Now that's interesting because it also has not responded to the polarization that characterizes so much of American politics today. This graph, this graph shows the support for the court according to the party identification of the respondent in the survey. And again, I think what the graph depicts is no relationship whatsoever. Democrats are not more supportive of the Supreme Court than Republicans, and vice versa. There's no partisan cleavage in the legitimacy of the U.S. Supreme Court. Nor is there an ideological cleavage. This is the same sort of graph, but it's showing on the x-axis ideological self-identifications of people, and that is to say whether they're extremely liberal all the way to extremely conservative. And if you look at the two extremes on that graph, it's pretty easy to see that extreme liberals assign as much legitimacy to the court as do extreme conservatives. So on partisanship and ideology, there's not very much variability in support for the court. We understand something about why that takes place. It may surprise you to know that performance satisfaction only weakly translates into legitimacy. At any given point in time, the relationship between being satisfied with what the Supreme Court is doing and willingness to extend legitimacy can be quite low, and indeed it's quite low in the United States today. There's definitely a relationship. Let's see. Yeah, there's definitely a relationship. So you can see on the right side of the graph that those who think the court's doing a great job extend more legitimacy. That's certainly true. But what's important about this figure is the asymmetry. The people on the right approach the highest point on the legitimacy scale, and their score is 4.6. The people on the left are 2.7 on a scale where the lowest value is 0. So there's an asymmetry here. Those who think the court is doing well, of course, extend legitimacy to it. Those who think the court is doing poorly, of course, extend less legitimacy to it. But those who think the court is doing poorly still extend very considerable legitimacy to the institution itself. The next attribute of public opinion is that legitimacy is consequential. It makes a difference for American politics. Now, I could talk about this in a lot of different ways, but with this crowd, I think I'll just mention Bush versus Gore. Because Bush versus Gore, in many respects, is the most demanding test on legitimacy that we could imagine. Think of Bush versus Gore. Extraordinarily consequential, right? It determines who's going to get the election. Court divided by partisanship. I'm not a great fan of the word activism, but it is true that the court was sticking its nose into an area of state law that it had not previously done so. And then we have Sandra Day O'Connor at the cocktail party, when told that Gore was likely to win, she told her friends that that would be horrible. So we've got a highly politicized case, and the question that comes out of the case is, will the American people, will elites as well, but will the American people accept the decision of the court, by which I mean acquiesce to it, by which I mean not lowering their support for the institution, by which I mean not responding to pleas from law professors and others to penalize, to punish the court for making its decision. Now, the research on Bush versus Gore is actually pretty clear. It turns out that the legitimacy of the court went up among Republicans. That probably does not surprise you a great deal. But it did not decline among Democrats, and it did not decline among African Americans, who in some sense were the group most likely to be aggrieved by the decision. I always think that Bush versus Gore is just the best example of how useful legitimacy can be to a court. I recognize that, like FDR, the dispute ended ambiguously, with Gore withdrawing. But I always like to think that Gore withdrew because he's read my research on the attitudes of the American people, and he knew that an attack on the court would be unlikely to resonate with ordinary people. Let me just conclude with a few comments about where legitimacy comes from. In a democracy, obviously, the clearest source of legitimacy for a political institution in a democracy is democratic accountability. I've said I'd say a couple of things about the states, and I'll say them here. We don't have a great deal of evidence about the legitimacy of state courts, but what evidence we have suggests that they're held in quite high esteem by the American people. I've suggested in my most recent book, Electing Judges, that the reason why state courts are held in such high esteem is because of the use of judicial elections. Now, there's probably not more than 3 people in this room who approve of judicial elections in any way whatsoever, and I'm willing to concede that there are a ton of bad things associated with them, but the research on this question suggests that despite the bad, the inherent boost to legitimacy from holding elections produces a net positive impact on the legitimacy of these state courts. So in my view, it's the elected state courts who have a quite natural source of legitimacy and therefore profit a great deal from elections. Obviously, U.S. Supreme Court's not in that category, right? It has a democracy deficit when it comes to selection and retention. We've discovered a little bit about why people do and don't support the Supreme Court. For a while, we thought that support for the court had to be grounded in the so-called myth of legality. That is the notion that judges are mechanical in their decision. They don't exercise discretion. They simply implement or find the law. Turns out the American people don't believe that one single bit. Turns out that the American people recognize that the court is a discretionary institution, a policy-making institution, that differences on the court are guided by ideology, mainly, but to some degree partisanship as well. And that understanding does not undermine the legitimacy of the court. I think if we look to Congress, I think we can see a little bit of the reason why. Why do people hate Congress? Well, they hate Congress because Congress people are insincere, strategic, and self-interested. It's not actually simply a fighting that people hate about Congress. It's the insincerity of the political process, and we can turn that around and look exactly at the Supreme Court. Yes, the Supreme Court is bound up in ideology. Yes, we have a perfect alignment of ideology and party today. But that doesn't threaten the court, and it doesn't threaten the court because people view judicial decision-making as principled differences between people. So we can have ideological debates on the court, and they do not threaten the legitimacy of the court of one single bit, so long as we avoid any appearance of self-interest in the outcome of the decision or any appearance of insincere strategic behavior. Now, I recognize our discussion yesterday on transparency applies here, because obviously there's a ton of strategic behavior on the court, but it's hidden from view from the American people, and that boosts the legitimacy of the court. So I'll just conclude by saying that if we look to the question of governability, I think the question of legitimacy is a very important aspect of that. And from the point of view of the American judiciary, state and federal, I don't see any governability crisis whatsoever. Thank you.
First of all, I'd like to thank Sandy for inviting me, and I'd also like to thank Sandy for focusing our attention not only on the federal Constitution, but on the 50 other constitutions by which we're governed. My focus in my research has been on state courts and state constitutions, and that's what I'm basically going to speak about today. The legitimacy question that Jim referred to and the data that he showed in support of the legitimacy of the U.S. Supreme Court stands side by side with a debate with which we're all familiar. On the one side, you have those who accuse judges of legislating from the bench and accuse them of reading their own values into the law. Usually these have been conservative critics. If anyone's ever seen the book Men in Black is sort of an indication of this sort of perspective. But post Citizens United, we've seen liberals join the chorus as well. For these critics, the solution is to bring out-of-control judges into some sort of accountability to prevent their overreaching. As the Chief of Staff of Senator Tom Coburn said, I don't want to impeach judges, I want to impale them. If the charges are familiar on that side, so too is the defense. And oftentimes this is made by the legal profession. Harsh criticism of judges and of their rulings, it is argued, tends to undermine public respect for the courts, confidence in the rule of law, and prevents judges from doing what they should do, which is to decide cases in accordance with the law. Judicial elections are likewise criticized as interfering with the even-handed administration of justice. The way to get the rule of law, then, according to those defending the courts, is to remove these external influences so that judges can get down to the business of deciding impartially. So both sides in this contemporary debate, and I call them the bashers and the defenders, both sides in this contemporary debate claim to support the rule of law, but they have very different diagnoses about what threatens it and very different views with regard to how that threat is to be dealt with. Defenders see the danger as coming from external pressures, from those who would influence or intimidate judges or induce them to decide based on popularity or on political expediency. The bashers view the danger as rooted in the absence of checks on judges, which frees them to pursue their ideological agendas at the expense of the rule of law. Impartial decision-making, the bashers say then, is best promoted by the prospect of some sort of accountability or retribution to keep judges in line who might otherwise be tempted to act inappropriately. The federal Constitution comes down emphatically on the side of the defenders, granting in Article 3 judges tenure during good behavior, and over time political practice has solidified this perspective. Think of the obsolescence of impeachment as a weapon against judges who are deciding cases what we view as wrongly. But the states have not arrived at the same conclusion. They haven't endorsed the defender perspective completely. And they've attempted to balance the basher and defender views in the way in which they design their institutions. So it's instructive to look at what they've done and how effective they've been in the designs that they've come up with. The defender view, as it's played out at the state level, is aimed at producing a sort of merit selection, taking politics out of the process of judicial selection. And indeed, the system that's for judicial selection that you see at the states, endorsed by the defenders, is called merit selection. The idea is that a panel, presumably an impartial panel, people not only by ordinary citizens, but by members of the legal profession who presumably know well the qualities of their colleagues within the profession, that this panel will submit a list of 3, or in some states 5, potential candidates to the governor, and the governor is obliged to choose from that list. Accountability, insofar as there is accountability under this system, is achieved by a system of retention elections, an thumbs up or thumbs down vote periodically, in which voters have the chance to decide whether or not Judge X is doing a good job or Judge X is not doing a good job and should not be retained in office. Basically, merit selection is failed. The purportedly nonpartisan commissions oftentimes include people who've been party activists. The lawyer members are oftentimes divided based upon the sort of interests they have in those who are on the bench. If I'm a plaintiff's lawyer, I want a particular sort of person on the bench. If I'm a defendant's lawyer, I want a different sort of person. If I'm a prosecutor, I want one. If I'm a criminal defense attorney, I want a different one. And so the commissions aren't merely apolitical. The commissions also undermine political accountability in that a governor need not take responsibility for his choices. The governor can say, these were the only people I had to choose from. If I had had my druthers, I would have appointed somebody quite different. Nor has politics been removed from the gubernatorial selection aspect of this merit selection. In Missouri, which is the state that pioneered merit selection, of those who have been selected to the state Supreme Court under merit selection, all but one of the justices has shared the political party affiliation of the appointing governor. In Bush v. Gore, which Jim mentioned, all 7 members of the Florida Supreme Court selected under merit selection were Democrats because there had been Democratic governors appointing them. Retention elections, likewise, have not worked out as well as perhaps those in favor of accountability would hope. Roughly 98% of all judges who come up for retention are retained. In the last election, 2012, all state Supreme Court justices who came up for retention were retained. What you have is a situation then in which individuals who are not qualified and sometimes who are not endorsed by the bar nonetheless are retained unless there's a strong campaign against an incumbent. Voters tend to vote in favor of the incumbent. When such strong campaigns occur, incumbent justices can be removed from office. We see this in 2010 in Iowa, shortly after the same-sex marriage decision. And so the merit selection process, the retention elections, do not insulate judges from these sorts of political campaigns based on disagreement with salient decisions. Merit selections failed in a couple of other ways as well. There's no evidence that merit selection, so-called, leads to the appointment of more qualified judges. In fact, the very limited social science evidence that we have seems to point a little bit in the other direction. And merit selection has failed to capture the popular imagination. From 1950 to 1980, 18 states adopted merit selection. But since 1994, no state has adopted merit selection. A number of states it's been proposed and voted down. And 2 states right now, Tennessee and Kansas, are in the process of jettisoning their system of merit selection to move more toward the federal model of gubernatorial appointment with senatorial confirmation. Bashers join with Jim in favoring the election of judges. They favor election of judges to relatively short terms so that the individual judge can be held accountable for his or her decisions. What defenders disparage as politicization, bashers tend to celebrate as democratization. And certainly what we see if we look at judicial campaigns in the states over the last few decades is we've seen a dramatic change in the character of those campaigns so they much more resemble campaigns for other offices. It was said at one time that a judicial election was about as exciting as playing a game of checkers by mail. That no longer is the case. What we've seen is increasing group involvement. We've seen highly rancorous campaigns. We've seen large amounts of money being funneled into such campaigns. And we've seen television ads as one of the main vehicles for campaigning. A television ad in Michigan in 2000, just to give you a flavor of it, a television ad in Michigan in 2000 accused the Democratic candidates of freeing killers and rapists. A campaign in 2004 in West Virginia accused the justice of having freed child molesters, and a campaign in Michigan in 2008 accused the Chief Justice of regularly falling asleep on the bench. Defenders insist that these... You did? What could be more successfully libelous than something that's true? Defenders suggest that this sort of what they call gutter politics does not produce well-informed voter choice. And there may be some truth in this, particularly if voters lack the voting cue of party affiliation in determining whom to select. The situation with regard to selecting judges is in some ways very similar to the situation of selecting others at lower places on the ballot. We don't have a great deal of information regarding the individual candidate. There isn't a great deal of media coverage, and therefore voters need some sort of cue in order to decide wisely. The main concern that defenders raise, of course, is that a sitting judge, a judge who could face such a campaign against him or her, may well be looking over his or her shoulder when making decisions, and when making decisions, particularly as the time for re-election comes up. The key here is re-election. Federal judicial selection is likewise highly politicized. But once the justices are on the bench, they're independent, given tenure during good behavior. The same is true, presumably, for Article III judges on courts of appeals and district courts, although there's at least the potentiality that judges' decisions may be influenced by the hope of advancement, say, to the Supreme Court. But in only 4 states do we have tenure during good behavior or tenure to a voting age, a retirement age, such as 70. And it seems very unlikely that we're going to move in that direction that pushes for more accountability rather than more insulation. And so re-election does, or reappointment, if it's an appointive system, does play a role here. A judge may act in violation of his or her oath in deciding cases. And even if they don't, even if they seek to be, to honor their oath, they can't be sure whether or not they're being influenced by the prospect of having to go before the voters or the appointing authority. Former Justice of the California Supreme Court, Otto Kaus, put it this way. He said, a forthcoming election is like having a crocodile in your bathtub. You know it's there, and you try not to think about it, but it's hard to think about much else while you're shaving. And so this may indeed operate. Well, what can be done? Judges could institute tenure during good behavior, but as I said, this seems unlikely. They could also, at least for their state Supreme Courts, choose a different model from outside the United States, such as we see in the constitutional courts in various European countries. Those courts pick their judges through a political process. The courts play an important political role, but judges serve for only a single term of office, usually around 9 or 10 years. This, it seems to me, is an attractive option for a variety of reasons. Judicial independence is secured because a judge knows that his or her decision will not affect tenure on the bench. When the term ends, the term ends. But judicial accountability is also promoted because periodically the electors in an elective system or the appointing authority in an appointive system have the opportunity to change the general direction of the court by who is next named to the court. So we get independence at the level of the individual judge, the individual deciding judge, but we get accountability for the court as a whole in the sense that political authorities will have input into the general direction the court will follow. Less fundamental steps might also be taken. One possibility is to strengthen recusal. And after the Caperton case before the U.S. Supreme Court, a number of states have taken steps in that direction. Usually the steps involve taking the decision with regard to recusal out of the hand of the individual judge and having a group of judges make the decision rather than have the single judge decide his own case. Another proposed reform is public financing of judicial elections. Only 4 states have adopted public financing of judicial elections, and given the fiscal problems that the states now face, it seems unlikely that many will seek to have this new expense as part of their budgets. Indeed, West Virginia, which set up a trial system of public finance, has now backed away from that. It may be that that's a good thing. It's not clear that public financing has worked to depoliticize elections. There seems to be some indication that with less money spent by the candidates, turnout has decreased. So if you're looking to have broad turnout in these races, public financing, just like nonpartisan elections, tends to reduce turnout. Beyond that, I think, just point to a single instance, one of the states that has public financing is Wisconsin. In 2011, if you may remember, there was this extraordinary race between Prosser and Koppenberg for a seat, what seemed to be a pivotal seat on the Wisconsin Supreme Court. Public financing did not reduce the amount of funding spent, it just changed the character of the funding. Individuals used independent groups rather than funneling money to candidates. And in a way, expenditures by independent groups are themselves sort of problematic because they have much less accountability than do the candidates themselves. There's another way of thinking about this as well. Let me go back in history for a minute. At the federal level, during his unsuccessful campaign in 1912, Theodore Roosevelt argued in favor of what he called recall of judicial decisions. The idea behind this was that if the courts made a decision with which the people disagreed, they had a chance to vote to invalidate the decision, basically. The decision would continue to operate for the parties to the case, but its precedential value would be eliminated by this negative popular vote. This, as you might imagine, went nowhere at the federal level. A couple of states adopted it for a short period of time until the judiciaries in those states found ways to render it ineffective. But we have something like that operating right now in the states. And the comparison between California and Iowa with regard to same-sex marriage cases points this out. In Iowa, after the Supreme Court ruled that the Iowa Constitution required recognition of same-sex marriages, the opponents of same-sex marriage went to the state legislature to seek a constitutional amendment to overturn the decision. They were unsuccessful in getting the legislators to propose such an amendment. And lacking the constitutional initiative, they therefore went after the judges. In California, you again had a decision recognizing same-sex marriage. The opponents of the decision did not go after the judges because they had a way to recall the decision, if you will, to recall the decision through the constitutional initiative. I know there's a lot of people who have severe doubts about direct democracy, but the example that you have there points out at least one perhaps positive aspect. To the extent that people are dissatisfied with the performance of the justices, are there ways in which you can deal with the performance without undermining the independence of those making decisions in good faith? We will say.
Good morning. I too want to salute Sandy for putting on this fabulous conference and for inviting me and for putting this panel together, which so far has been terrific, and now we'll take it down to lunch. So I want to agree with Jim and then ask a question about what Jim said. I think it's quite right that support for the Supreme Court is very, very high. We treat these able, highly credentialed lawyers as demigods, and spend much too much time thinking about them. They're not particularly hardworking. Last year they decided 65 cases and signed opinions after argument. That's not a lot of work for 9 people with 4 brainiac law clerks each. And this is at the expense of coverage of state Supreme Courts and courts of appeal, where a lot of the real work of the law gets done. But be that as it may, it is the case that support for this mysterious institution very, very high. And then my question is, I don't doubt that Alan Gore took a look at Jim's work before deciding not to attack the court, but why is it that the court, notwithstanding this prestige and authority that it holds, is not buying Jim's thesis and is in fact quite afraid of admitting that it makes ideological, policy-driven political choices? Why is it that at Chief Justice Roberts' confirmation hearing, he goes out of his way to use the umpire analogy? Why is it that Sonia Sotomayor essentially presents herself as a law robot? I take the facts, I apply the law to the facts, and it generates a result. They don't spend enough time with your work, I think. And you know, in private conversations, I'm here, I guess, as the sole representative of the media in all of this, and we haven't gotten an especially good ride in this conference. I'll now reinforce that view. In private conversations with justices, in just about so many words, I'm told, your job, Adam, is to make us look as political as possible. My job is to make us look as apolitical as possible. It seems very, very important to them to seem apolitical. And they're not wrong. I mean, I hope the critique is not true of me, but they're not wrong in the press generally that the editorial impulse is to find the political angle in a decision that could well be explained often in purely legal terms. I was talking to a quite distinguished journalist who applied for a job covering the court at another paper, and he said, I told him I wanted to get more legal. And the response was, but that would make us look naive. So there's some truth in the critique of the press that at least elements of it don't want to engage on what is very often authentic, difficult legal questions with no special ideological valence. But at the same time, I think a good way to illustrate this tension is with a quote from my colleague Lyle Dennis, who's covered the court for literally more than 50 years. If there's a job with life tenure in the American press, it's Supreme Court coverage. So my predecessor, Linda Greenhouse, covered the court for 30 years, and when she retired, she was the 3rd most senior correspondent. And the reason that the journalistic idea generally is to move people from beats so they don't get captured by their sources. That's not really a problem. Or by the institution's values. Now that is a problem. And this quote I want to read you from Lyle, I think may illustrate this point, that if you're there long enough, you may take on the values of the institution. And again, this reflects the point that they're not getting Jim's research because they think there is a risk to their legitimacy and authority if they're seen to be political. Now, Lyle wasn't writing about a Supreme Court case. He was writing about a Court of Appeals decision recently out of the Sixth Circuit, and he wrote, readers will find in some news accounts about this decision references to the political party affiliations of the presidents who named the judges to the bench, referring to them as Democratic or Republican appointees. The author of this blog will provide the information only when it is clearly demonstrated that the political source of a judge's selection had a direct bearing about how the judge voted. Admittedly, a very difficult thing to prove. Otherwise, the use of such references invites the reader to draw such a conclusion about partisan influence without proof. Now, that is completely in keeping with what judges want us to do. Judges hate it when the recess appointments decision that came down yesterday, in the Times account online at least, we identified who appointed which of the 3 judges. It happens they're all Republican appointees. Now, Lyle's point, I think, is probably made in a context where he's really picking a fight, because he was writing about a Sixth Circuit decision that was an 8-7 decision, throwing out a Michigan constitutional amendment that would have prohibited racial preferences in higher education and elsewhere. And in 8-7 decision, all 8 of the votes in favor of throwing out this constitutional amendment, which is to say the liberal side, came from Democratic appointees, all 7 from Republican appointees. And I ask you whether it's not a kind of journalistic malpractice, at least in that setting, not to note it. Let the reader make of it what he or she will. I don't know, maybe it's a coincidence. I'm not a statistician. I don't know. But that does tell you that the culture, which I think Lyle reflects in what the court would want us to do, is to say that's happenstance. Or to play the shell game of, well, yes, you know, it's not political, it's just judicial philosophy that happens to generate precisely the same result as the political analysis would. Now, when I wrote about this, I tried. I don't come encumbered with a lot of data, but I did try to see what can be known in this setting, and University of Texas, particularly apt place to talk about it. What can be known about, call it ideological voting, in the context of affirmative action programs. And Cass Sunstein and others in 2006 did some work, and they found that over hundreds of cases in the courts of appeal, Republican-appointed judges voted to uphold affirmative action programs 47% of the time, and Democratic-appointed judges 75% of the time. So there's a 28% gap. This is from 78 to 04. And then in their recent and very interesting and good book, Lee Epstein and Judge Posner and Bill Landis updated the numbers slightly. Republicans uphold 41% of the time, Democrats 66% of the time from 95 to 08. So that's a 25-point gap. Now, I think that tells you a couple things. My editor's response was, that's all? That law controls most of it, but not all of it. And so the takeaway from the Landis, Posner, and Epstein book is judges are not only politicians in robes, but among other things, they're politicians in robes. And I think Jim's analysis affirms that and says people don't seem to mind that. And yet, then I repeat the question, why do judges seem to mind having people know what people don't care about? As Jim mentioned, the current court is, for the first time in living memory, perfectly aligned between party of appointing president and ideology. So all of the 5 more conservative justices were appointed by Republicans, all of the 4 more liberal ones appointed by Democrats. And when you think about it, that's an anomaly, because Stevens, Souter, Brennan, Warren, there are lots and lots, I mean, they tend to go in one direction, but there are lots and lots of exceptions to that. And I think that the healthcare decision can be explained in part by Chief Justice Roberts' failure to engage with Jim's scholarship and not understand that it would have been fine with the American public for the court to split along, call it partisan lines. And instead, he abandons his usual allies, and for the first time in his years on the court, joins the 4 liberals in any case, but certainly in a highly controversial case. And that was, I think, because he thought an attack on the court could resonate in that context. And I also think that President Obama was ready to attack the court and was already laying the groundwork for that. So the president also seems not to be familiar with this thesis, because the president seemed to think that it is possible to delegitimize the court by attacking it along these lines. We will see what happens in the Fisher affirmative action case out of Texas here, but I think that a pretty good prediction, it could be a hard landing or a soft landing, but a pretty good prediction is that will be a 5-4 decision along ideological lines, and that would fit with the Sunstein and other data quite well. Now, they made me write a bit. I don't understand public opinion polling very well, but we did some polling around the healthcare decision, and I had thought going in, I thought the conventional wisdom was that the court's polling in this sense of public approval ratings was both quite high and quite stable. And in fact, at least on polling, which is not exactly what Jim was talking about, not so much, and dipped quite substantially around and after healthcare. It's come back some, but it was 44, 41, and right in the level of the presidency. I had thought it was higher, much higher than Congress, but sort of neck and neck with the presidency. After the healthcare case, Nate Persily and Andrea Campbell wrote that the court pulled off a really neat trick. They increased support for the law and decreased confidence in the court. They called it, the decision, the most polarizing instance of judicial restraint on record. And there were very, very different opinions among Republicans and Democrats about how they felt about that case. Here too, I don't know if the court follows polls in the sense of doing what polls want them to do, but I do have direct evidence that they follow the polls in the sense of following the polls and, you know, try to make sense of them. So, you know, we asked a question about whether justices are sometimes influenced by personal or political views, and the answer was 75% of people said yes. And a justice says to me, well, yeah, sure, if you say sometimes. So following the polls, at least in the sense of trying to figure out what the questions are and being quite alert to the results, for sure. So I want to turn for just a second to the state courts, because I do, you know, we have a crisis in journalism, but not a crisis in coverage of the Supreme Court. The Supreme Court way over-covered. The legal coverage of the rest of the legal system is in a bad way, and we still do an okay job. Other papers have withdrawn from the field entirely. And I guess it's been a while, but in 2006, a colleague and I, Janet Roberts, tried to do a little empirical work on campaign contributions in the context of the Ohio Supreme Court. And we looked at 12 years of data and found that on average, justices of the court ruled in favor of the party who had contributed to their campaign 70% of the time, one guy 91% of the time, and a Republican justice on the court, Paul Pfeiffer, gave me a quote, which I think was the quote of the day. I really appreciate it. He said about fundraising, which they do. I never felt so much like a hooker down by the bus station in any race I've ever been in as I did in a judicial race. Everyone interested in contributing has a very specific interest. He said, I don't know if they can buy a vote, but they're trying to buy a vote. And maybe I'll close with this thought about judicial elections, which if you're troubled by the Lesters in the political context, I think it's somehow, I can't quite articulate it, but it seems doubly troubling to have the Lesters be able to put judges on benches where the litigants are hoping for a fair shake. Now, I'm not sure that I'm hoping for a fair shake from Congress. You know, Congress has its commitments, and they got elected on a particular platform. I don't know that that's what I want from the judge hearing my case. And I don't know that correlation is causation here. That is, I think it's perfectly possible that people support those judges who are going to vote in the way the judge was going to vote before they got the money. But even that seems more problematic to me than in the political context. So I am not one of the three people, or however many, who think electing judges is a fine idea. It is at least food for thought that we are almost literally alone in the world in this odd practice. When I wrote about this a couple of years ago, I think the Japanese Supreme Court and a couple of Swiss cantons were the other places that elected judges. Well, anyway, thank you.
Well, another thing that makes the United States unique is life tenure for our federal judges. This is an idea that Sandy and I have joined Paul Carrington's lead in proposing that the Supreme Court be shifted to a single non-renewable 18-year term, staggering it every other year with a vacancy. And I think Jim's work helps explain why this very sensible proposal doesn't get any traction except with aging academics who constitute the supporters. But one of the things that is quite noticeable, and I think you saw it with Stevens and Souter, they did outlive George Bush's presidency and then retired. And I'm willing to bet that we will see Scalia and Kennedy waiting at least 4 years before they offer their retirements. And justices are giving to the president's party the right to replace them. And thus I would like to raise the question, Are there any other supporters of a single 18-year term?
I think I'm vaguely in favor. I mean, I don't think the framers expected people to live this long. I mean, I don't think they expected Justice Stevens to live till 90. And I don't know how easily achievable it is. I don't know how big a deal it would be. I think there's a little bit of a danger if someone knows the end point and is still interested in a career. It's possible they could shade their decisions in order to get that next job, and that's got its dangers. Larry and I were walking over the other day. He proposed something that was, sort of too smart for me, but maybe making a lottery so they, every 2 years or 6 years or whatever, you pick a name out of the hat so they don't know which one of them it's going to be. Or maybe you could do a kind of America, vote them off the island kind of thing. Right?
I'm not sure I'd endorse the Russian roulette approach that's been suggested, but I think if you don't do a single term, you could use a retirement age. That way we're not worried about them at the end of their career looking for another job. But there's something very unedifying about justices being able to choose their successors.
And Jim, I had a question for you. When you were putting up the nice figures that no one else could see, it turned out that the people that were least supportive of the court were those either identified as independents or middle of the road. Do you have an explanation?
Yeah, as you know, people who are independents or middle of the road are the least informed, the least democratic of all of the citizens. It's not that they're independents because they know too much about the two parties and reject both. They're independents because they know so little about the two parties that they can't declare. And so it's a little bit an artifact of the scale. They often answer that they're uncertain about the Supreme Court. They don't know about the Supreme Court, and therefore they're unwilling to register strong pro-feelings.
What do we know about what people know about the court? Because my sense is almost nothing.
That's a good question, and so I'll take just a second on that. We know that they know nothing because of the research of the American National Election Studies at the University of Michigan. Well, I became suspicious of those data because they don't comport with my findings. So I looked into, I'm being honest about that. So I looked into their coding of the question, and the one that's often reported in the press is 3% of the people know who Rehnquist is. Rehnquist is good because he was around for a long time, and what his position was. Now, I looked into that, and so if you say Rehnquist is a Supreme Court judge, that's wrong. If you say he's the head honcho of the Supreme Court, that's wrong. If you say that Rehnquist is the Chief Justice of the United States, which he is, that's wrong. The only way that Michigan would ever score a correct answer is for a person to give the wrong answer, technically, and that is that he's the Chief Justice of the United States Supreme Court. Now, this ANES, the American National Election Study, has embraced these critiques and findings of mine and have done a major reconsideration of all of the open-ended data. But what we find is that the American people know orders of magnitude, never believe this 7 dwarfs and they know more of the dwarfs than of the Supremes. That's a horrible question. They know orders of magnitude more about the Supreme Court if you just ask the right questions.
Now, we're going to get the right questions. I'm going to throw it open to the audience.
John Rowland, Constitution.org. At the Constitution Society, we are flooded with reports, credible reports, of all kinds of pathological events in the judicial sector. A general sense that there's a lack of accountability on the part of judicial and other officials, a failure to provide easy access to just remedies. And it takes various forms such as extending immunity, blocking public access to grand juries, denying private prosecutions, blocking legal argument to juries, and the failure to generally adequately process complaints of judicial and other official misconduct. So let's examine the growing perception, which I think you'll find if you really examine public opinion, that the judicial system is not in fact working well, even if there is a general sense of legitimacy for the courts on the part of the less informed public. The more informed segment of the public is extremely disturbed, and rightly so.
If I may, just on that last point, one of the strongest findings that we have that's been replicated over and over and over and over is to know them is to love them. And what I specifically mean by that is that support skyrockets for courts among people who are knowledgeable about them.
I mean, one thing to bear in mind is consider the other branches of government. These folks on the Supreme Court are really good at their jobs. It's a technical, formal matter. They're superb lawyers. And, you know, compare that to the quality of the discourse you get out of Congress. It's just a different scene.
But I think what you're pointing at is really, the issue is not the level of the Supreme Court, it's the level of trial courts and so on and so forth. And that's an area in which obviously improvement is possible and should be made.
Yeah, this is a question I think for Jim and Adam about the relationship between the Supreme Court and Congress. Jim was talking about legitimacy in the public, and I'm wondering if the shift that both of you described, where all the conservatives are now Republican appointed and all the liberals are now Democratic appointed, is going to have an effect on the confirmation process going forward. And I'm thinking about, you know, kind of the reason we now have this partisan realignment on the Supreme Court is the lag that comes from having life tenure that takes a while to get here. But I was looking at how Congress can affect what happens on the Supreme Court, and there's been a dramatic decline in the number of times that Congress overturns the Supreme Court statutory decisions, going down from an average of 12 every 2 years to less than 3 every 2 years in the last period. But at the same time, there's been a rise in the number of no votes for confirming Supreme Court justices. So when Kennedy and Scalia, they got unanimous approval. Breyer and Ginsburg, I think it was 6 or 8, voted no. But then you get to the last 4, Alito, Roberts, Kagan, Sotomayor, it's in the 40s. And Alito was 42, could have been filibustered. And I'm wondering what you see in terms of how this legitimacy is going to play out when it's time that Scalia retires, or Kennedy retires and leaves the court.
If we have a situation where the balance of power in the court would authentically be altered, which is to say one of the 5 more conservatives dying or retiring in this current administration, it will be a battle royale. I mean, it will, and partly, and Rick did a nice paper on this, partly because the power of the court has only risen in recent years, because as its constitutional decisions always have been, its statutory decisions now are essentially unrespondable to, because of the way Congress is so polarized. So it's hard for me to predict, and it's not the branch I know well, but you could really imagine, real fireworks. And of course, the reason the Alito vote was so high, the highest in recent years, is because he was the only switch that made a difference in the last 4.
I want to get on the record before we run out of time that Adam Liptak and I are in strong agreement that the Supreme Court ought to be reading more of my work.
I'll be dropping this off at the...
But let me give a serious answer to that question, because I focus on the mass public and sociological legitimacy, but it's really a 3-part conflict here between the court, elites, and the mass public. Okay? the way I conceptualize the process is that there are always elites who are willing to attack the institution. They put forth every year these incredible court-curbing bills on jurisdiction, Ron Paul and all of them. And so the attacks are always being made, and the attackers are hoping that their bills will resonate with the American people, and because of legitimacy, they do not. But justices are nonetheless concerned about the Congress itself, irrespective of people. I commend to you Tom Clark's recent book on exactly this issue. It's a brilliant analysis of this three-way conflict between the court, the American people, and other institutional elites that have the power to do considerable damage to the integrity of the Supreme Court.
Larry?
So, Jim, I was excited to hear you say that the hatred of Congress you thought was tied more to the insincerity, strategic behavior, self-interested character of Congress than to their fighting. It's the first time Fairjohn's ever been wrong about anything. You can flag it and mark it. I wonder whether your optimism about the public's understanding of state court judges is just a lagged optimism, in the sense that if, Adam's work and other people's work about the way in which the funding of judicial elections has undermined the trust of lawyers and judges about the work of judges suggests that eventually, the public gets this view too. So if the public begins to believe what many lawyers and judges believe, which is that judges are making decisions for self-interested, strategic reasons to help them fund their campaigns, why wouldn't the same kind of cynicism spread to the public, and the public eventually become as skeptical about state court judges as they are about Congress, and then the choice to make judges elected no longer tilts in favor of confidence building, it might be confidence.
That's an absolutely great question. And I want to invoke this book, which is my latest book on the state courts, but the one before it as well on the Alito nomination. Now, I'll give you a very brief review of those in answering your question. The Alito book showed that the advertisements run for and against Alito did indeed do damage to the institution of the U.S. Supreme Court. So this politicization, these ads that say, the right wing has captured the West Wing and they're trying to get the court too, that level of discourse does indeed do damage to the institution. So I'm agreeing with you 100% there. Now, there's nothing about the federal process, however, that rejuvenates support. At the state level, all of the bad things exist and they have bad effects. I wanted the subtitle of this book to be a reply to Charlie J. Do judicial elections really stink? His famous article. Yes, they do stink, but they stink in the context of people being reminded. They may not know in February, but they're being reminded in November that their judges are accountable to them, and they want that accountability. And that boost of accountability, we've shown this in two contexts now, that boost in accountability overwhelms the bad stuff. So the message of this book is that in thinking about methods of selection, we need to look at net effects. Yeah, there's all kinds of bad things that come from attack ads. There are bad things from campaign contributions, to be sure, but other aspects of the selection process can neutralize the bad things.
Can I just follow up, because I maybe didn't put the question strong enough. Is it the case that the public actually has the same understanding about the way campaigns are funded that the lawyers and judges do? Because the good effects might outweigh the bad effects in the context of ignorance. But in a world where the public begins to read Liptak as much as you want judges to read your work, and understands the relationship between funding and what judges are doing, the public's understanding of this good event might change.
I think that's possible, but I think Adam mentioned Caperton. And I think it's important to look at the facts. You're assuming that the facts are all going to create negative reactions, right? You've got to remember that Brent Benjamin, the offending judge in Caperton, who did nothing, by the way, he was simply the beneficiary of independent expenditures by the head of his coal company. He voted 3-2 in favor of the coal company. So two other judges who weren't conflicted in any way whatsoever reached the same conclusion as Benjamin. Case goes up to U.S. Supreme Court, returned to West Virginia, 4-1 for the coal company. So it seems to me that if we have a careful examination of correlation and causality on campaign contributions, that perhaps the American people will not view them nearly as negatively as you assume.
Heather?
So I have a comment and a question. The comment is to Adam. I'm not surprised at all that the justices who possess this robust form of legitimacy are very cautious about it, mostly just because they're human beings. So one of the things I'd like to do best is to go talk to a member of Congress or state legislature and tell them the odds of you being voted out of office are the odds of being hit by lightning. And they just hate that because they are constantly on the edge, constantly worried about the possibility that they might get voted out. So there's just a way in which they can vastly overestimate the odds of something happening. And even private, they're all pretty, I think, frank and private judges, but they don't want to be public about it, sometimes because they don't want to get confirmed. But because they played the first year con law game, right? So the con law professor says, aren't they making policy judgments? The first year student says yes. Well, then why did they get to do that? And I think they're just worried about that second sentence. Is that there's not a particularly well-formulated answer to that, with all due respect to the academics in this room, that can be explained in 3 sentences to the American public. So there's lots of, arguments we come up with as law professors as why they can do that. The question I have, though, is a little bit on the lines of Larry's question, and it's about the relationship between legitimacy and ignorance. So, I was in chambers when David Souter came back with an angry look on his face because he had just told Congress that cameras would roll in to the courtroom over his dead body. And I always sort of thought that the Supreme Court would do well by having more publicity cameras in the courtroom because they're so remarkable, such remarkable lawyers, such a serious event. But as you sort of look at what's happening between Congress, the President, and the court, it's almost directly related to how much we see of them. So I understand they know the justices' names, but they don't see them. They see them in robes, and they get their stentorian opinions and pronouncements on a document, which all seems very dignified. But we don't see how silly human beings they can be, and in the same way that we do with members of Congress, and the President is somewhere in the middle. So he's cloaked with a very dignified office, and often has the advantage over members of Congress in terms of what the American people see and how we can control it. So I just sort of want to push on this. But judicial elections is a perfect example. The more campaigning there is on judicial elections, the more we see of them, what they really look like. And I wonder if over time that doesn't end up undermining legitimacy.
So I think the real reason they don't want, cameras in the courts is a nice way to think about this. Because on the one hand, and Kagan said this, she's since changed her mind since she went on the court, it's extraordinary. The quality of the advocacy and the questioning and argument is really something to see. And if you want to see a branch of government doing its job very well, go to a Supreme Court argument. It's exceptional. At the same time, they are correctly concerned, in the age of YouTube and Jon Stewart, that the one goofy thing, the one comment from Breyer saying people used to stick things in my underwear, will take on a life of its own that really will subject the court to mockery, and this is not an institution that's really open to that particular valence. So even with Justice Souter off the court, it's really, really unlikely to see that, because I think they know, and I think they're right, that they're better off to be mysterious.
We've just finished a paper, and I won't say very much at all about this, but we've just finished a paper in which we've shown that when people are told about the Supreme Court in the context of the symbols of the court, they're much more likely to accept objectionable decisions. And so the experiment, and it's a true experiment, we tell them about an opinion, half of the people get robes and cathedral buildings and blah, blah, all the symbols, and the other half get abstract symbols that mean nothing. And those who get symbols are remarkably more likely to acquiesce to and support the court. So it's a very much Danny Kahneman system 1, system 2, thinking fast, thinking slow kind of argument. So I've always, South Africa is my adopted home, and I've talked a lot to the Constitutional Court there. And I said, y'all are crazy not to wear robes. You're crazy not to call yourself justices. In fact, my recommendation is wear wigs, because these symbols are real powerful and real useful.
In actuality, if we look beyond the U.S. Supreme Court, a number of state Supreme Courts do televise. In some states, the state Supreme Court goes on the road and holds hearings in various parts of the state, so the people who could not see it directly in the state capitol have a chance to see it. It seems odd to me that we accepted it is appropriate for people to go into the courtroom and see the court, but we don't accept that they can see it from their home.
Oh, just to be clear, there's absolutely no principled reason to exclude cameras from the courtroom. I mean, not to let citizens see their government in action is crazy.
Before I get to go, just a comment following up on Heather, it seems to me that Justice Scalia has, in some very profound ways, changed the job description of a member of the U.S. Supreme Court, in that confounding original predictions of what it's going to be like. He really has devoted much of his career to directing his attentions outside the court, constantly speaking to groups and building a base for his particular take. And it seems to me this helps to explain why Steve Breyer, who one would not have predicted on the basis of knowing Professor Breyer from the Harvard Law School and First Circuit judge, ends up being on Larry King and traveling with Scalia to Texas Tech for a debate in front of 5,000 people on the role of the court. Justice Sotomayor is on a book tour. She was in Austin Friday. And my suspicion is that Elena Kagan, who is an unusually gifted public speaker, will start following the Scalia route, not necessarily be nasty to her colleagues in the way that Scalia has specialized in, but going out to build public support for her view of what judges should be doing. So that David Souter, I think, is not only an anachronism with his dead set opposition to cameras, but I don't know that he ever spoke while he was a justice. Heather might know.
Just once or twice, and it was the subject of the parodies for the clerks.
I mean, this is not what
We
he
YouTubed it, and
what he wanted to do.
They have time on their hands. They're treated like gods. You go to the Texas Tech and you're Scalia or Breyer, that's got to be good for the ego. They say it's probably true that they're not only building their own base, they're building support for the court because people, oh, he's such a nice guy, I respect the court now even more. And from a journalist perspective, it's all to the good. It's also, books are essentially, aside from a little bit of teaching, the only way they can earn outside income. So Justice Sotomayor made quite, $1.5 million in advance on her book. So there are a bunch of reasons for this, and God bless them. The more the merrier.
Well, very casually and almost in passing, Adam Liptak made a point that I think bears very directly on the subject of this conference and profoundly, and that is that if we look at issues of governance, we bring different expectations to different aspects of the governing system. And the adage that we have the best Congress that money can buy elicits a range of reactions from outrage to amused resignation. But when we look at the judiciary, my proposition, which is based on all of human history, is that we will not accept the best judiciary that money can buy. One of the oldest tropes in literature, you can look at the Bible, you can look at anything, is the idea of judicial corruption as being related to a cash or pecuniary nexus between, that links and influences judicial decision making. And I want to suggest that certainly from a normative standpoint, and probably from an empirical standpoint as well, that if citizens of a particular state, particular jurisdiction, really come to believe that judicial decision-making is being driven by a pecuniary link or interest, that will have a very profound effect, not only on the quality of the activity of that institution, but on the public support for it. And I cannot believe, therefore, that we are describing a stable situation here if judicial elections are more and more heavily funded by the kinds of people who have a direct interest in the outcome. We live in a culture of suspicion and mistrust, and I can't believe that that won't play directly into that, and that strikes me as a very powerful argument against the idea of heavily funded elections of judges, despite the fact that people want democratic accountability. But that's not all they want. They also want a non-corrupt judiciary, and I would predict that they want a non-corrupt judiciary more than they want an elected judiciary if they have to choose.
You've set up a straw person, however. Let's talk about just a moment, for a moment, an Iowa Supreme Court decision. And that is the decision that an employer can fire his assistant because she's too attractive and stimulates him sexually, and he doesn't want to get in trouble with his wife, and therefore he can fire her.
The legal term of art was irresistible.
Thank you. It's probably employment at will, some kind of employment at will doctrine that's at stake here. Now, are you suggesting to me that the American people would, or the Iowa people, would recoil against an effort by the National Organization of Women to get judges on the Iowa Supreme Court who are more sympathetic to the rights of women in the workplace? The scenario that you've set up is a quid pro quo from an instant case. And as Adam and others have suggested, maybe recusal, maybe there are other mechanisms. But y'all wouldn't want to forbid the NAACP Legal Defense Fund from supporting efforts to get pro-black judges on the bench, would you? It strikes me as an inherently democratic position that people, given that we know from Sunstein and all the work, given that we know Democrats and Republicans are different, it strikes me as inherently acceptable to the American people that Democrats would try to get liberal judges on the bench and Republicans would try to get Republican judges on the bench.
That's not what
Why
I'm talking about.
wouldn't a judicial election with fixed terms meet both your and Larry's objections, desires? You would get your judicial election, but you wouldn't have any potential for the future. Larry?
Well, there's still the question of who's funding the initial election. But I actually don't think you responded to Bill's point. I think Bill was talking about somebody on a principal, position advancing particular candidates. He was talking about a perception that it was specific financial interests, like, for example, the Illinois cases which the court didn't take when they took the Caperton case, where the Illinois insurance companies basically bought Supreme Court justices on the Illinois Supreme Court. And that perception is not about whether we should have a better perspective on insurance law. It's about how do we make sure that we get the return that we want. That's the corruption of employees.
But how do you know that was the objective of the insurance company? I'm actually quite serious.
I know you. Well, let's ask the question slightly differently. I think we all agree, or it's certainly ethically conventional, that a judge who owns a single share of stock must recuse him or herself from the case. Trivial interest. It knocks Supreme Court justices off cases. Nobody thinks they're going to vote differently because they have a share of AT&T. And yet, that's conventional wisdom, that if you've got a stake in the case, you got to step aside. Why isn't it a stake in the case that someone gave you $1,000?
Okay, last question.
A couple of quick comments and then a question. On the 18 years of the Supreme Court, I think the prospect that they would worry about shading their decisions for future jobs, given the opportunities they would have anyway, probably is a small risk, and you could give them an ample pension. And an amplification on the sort of defenders or bashers, I guess. One of the ways that for the accountability in elections that is true in my county is a way for minorities who are shut out of the appointment process because they're not part of the majority elite. Elections gives them a way to break into the election. So in our case, it's the African American minority. They see elections as their path to the judiciary. And then my question for Adam is, the phenomenon that and this is maybe not a fair perception, that the conservative presidents are more willing to appoint very conservative justices than Democratic presidents, very liberal. That you pointed out, Alito was not filibustered even though the votes were there. And maybe it's just the right word to the country in general. And after all, Democrats did block Borg, but there is a sense that the liberal wing is more of a moderate wing, and the conservative wing really is a conservative wing.
So as a descriptive matter, that's correct, that by historical standards, the current liberals on the court, not particularly liberal, neither Clinton nor Obama really cares as deeply about the courts as the right does. I guess that may be true of the Democratic Party generally. Some of them seem half embarrassed by the greatest victories in the Warren Court years. And Obama has said that he's going to do his work in the political branches, and that the court is sort of a holding action. So that, as a descriptive matter, I think you're quite right.
I would point out that the current U.S. Supreme Court is making conservative decisions in 58% of the cases, and 42% are liberal decisions. So what that's doing, it seems to me, is providing every segment of the American population with pleasing and displeasing decisions from the court. And that actually turns out to be a good thing, it seems to me. Everybody wins and everybody loses. And that neutralizes the effect of dissatisfaction with policy on the erosion of support for the court.
Well, I'd like to thank the panelists. I think they did a terrific job.